Good evening, everyone. I'm going to call the September meeting of the Washington County Quorum Court to order. I want to welcome everybody here this evening. Good to see our colleagues as we sit and do the business of Washington County. With that, we're going to do the prayer and pledge, and I believe Justice Rios Stafford has agreed to do us that honor. Justice Rios Stafford.
Thank you, Judge. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Justice Rios Stafford. With that, we're going to move to the adoption of the agenda. Do I have any motions to adopt the agenda? Motion by Justice Lyons, second by Justice Lemming. All those in favor? Aye. Those opposed? The agenda has been adopted. Item number 4, are there any preliminary motions this evening? Justice Dean?
Yes, thank you, Judge. I'd like to make a motion that all ordinances and resolutions be read by title only.
I have a motion to read ordinances and resolutions by title only by Justice Dean. Second by Justice Washington. All those in favor? Those opposed? Ordinances and resolutions will be read by title only. Item number 5 is our citizens' comment period. We have a 15-minute comment period with a limit for 3 minutes per individual. Any citizen comments this evening? You have to push the button on the very right. Should cue that mic up on the right. Oh, sorry, this right. You're right.
Got it?
Should be good. Please state your name and where you're from for us,
yes,
please.
Thank you. My name is Cecily Duncan. I'm a resident of Washington County, and I have been reviewing the Freedom and Preservation Property Zoning Act of Washington County for the last couple of days. I want to start by giving our county officials a compliment on the particular zoning ordinances. I know that's been underway for several years, and a lot of time, effort, and thought has gone into it. One of the things that I do want to point out is that the GIS map on the county website is inactive, and therefore citizens in the county have not had an opportunity to actually see the new zoning going through. And I think that level of transparency is really important prior to any voting taking place on that ordinance. The other question I have is about the specific zoning. In the proposal that I read, it was designated C1 and C2. My understanding is that with my conversation with Sam Atta at the county, that those designations have been amended, so it's a single designation. I have not had an opportunity to read the final proposal for the zoning, so I have not had an opportunity to answer questions around those specific designations and how larger retail developments would be out in the county. Secondly, there is nothing in the proposal that deals with water usage in developments that may be coming to the county. I think that is incredibly important that we deal with water preservation, specifically because my family, of which there are several members, and all of my neighbors have issues with water availability in the county as it stands. We have been on that land for 4 generations. And so I feel like we need specific language around water preservation. I want to see us look at alternatives for grass lawns like clover, which sends deeper roots into the soil and is a nitrogen fixer. It reduces our reliance on waters. That is going to reduce bills for families and for in terms of utilities, and the reliance on fuel for gas-powered motors and chemical fertilizers. I would like to request specific language be included in the proposal for those items, as well as specific words around marshes, wetlands, and ponds, of which are represented 0 times in the 168 pages of the county proposal. There needs to be specific language to those specific areas around preservation. Lastly,
you got about 10 seconds left.
Thank you. Well, I will close my comments then, and thank you all very much.
Thank you. Next public comments.
Terry Davis, Beaupre, Weddington Woods. This planning and zoning document should not be in ordinance form yet. What good reason would you have for keeping 178 homeowners in the dark about a high-intensity, high-impact industrial land use change only until after the rezoning is approved? In a recent email to JP's, I've cited 3 real-world instances where, as this document is written, up to 95% of neighboring residents would be excluded from the process until the planning board's preliminary review meeting. On page 14, it specifically states that neighbors only within 300 feet would be given 14 days notice instead of the 1/2 mile notification and 30-day notice that is later required by the planning board. In response to a question on April 1st of this year, Brian Lester, at 2 hours and 16 minutes into the County Services Committee hearing, explained that under the overhauled ordinances, JPs would only be involved with land use changes during the rezoning step. This is incorrect. On pages 80 and 81, there are still 2 instances where both planning department denials and approvals are heard by the quorum court. This is contradictory to instructions on page 46, where it says appeals are to be heard by the county judge. Brian Lester also said during that same exchange on April 1st that all rezoning request ordinances would go to a county committee of some sort before coming to the quorum court. That is not stated anywhere in this document. Page 45 directs large-scale developments with hazardous chemicals to give 30-day notices to neighbors within 1/2 mile for both the preliminary and final plat review stages. This runs counter to defined instructions for large-scale developments found at the top of page 5. And then again, the homeowners who live just over 300 feet from these hazardous chemical large-scale developments are ignored in the rezoning stage. Last month, at 9 minutes into the August 28th Planning Board meeting here in this room, Brian Lester said that we have a list of criteria that will be used by the JPs when they consider a rezoning request. That list, as it relates to the rezoning consideration, is also not anywhere in this document. These are only a few examples. It looks like much of this has simply been cut and pasted from the current ordinances and then proofread by someone who doesn't understand how the new process is supposed to be different from the old. This document is ambiguous, incomplete,
Thank you,
and
ma'am.
contradictory.
That's time.
I still have 15 seconds left.
I'm sorry, I'm the timekeeper. You need to step away from the podium. Sir, would you like to have your public comment time?
Yes, I would. I'm Steve Green, live near West Fork. Family's been here since the 50s. And I found this map of rezoning with the pink areas shown on it for rezoning to commercial use along rural highways and in rural areas. And I'm perplexed about it because people come to Washington County for the unspoiled natural beauty. It's why people come here, for the beauty of our roads. And if we rezone to commercial along all these roads here, then we get away from the conditional use permit process by which the property rights of existing landowners are respected, and we go to the commercial process where the approval is all within the county government and existing landowners have their property rights trampled on. But the really perplexing thing is people come here for the natural beauty, not for miles and miles of car lots and junkyards and cut-rates appliance barns along our highways. They come here because it's beautiful. An anecdote in West Fork, a gentleman from Asheville, North Carolina, which is a pretty good place, drove up from Alma and said, I fell in love with this place on the drive up 71 from Alma. And that road, the Boston Scenic Loop, is on the list to be changed to commercial. This is just wrong-headed for the benefit of the county. It's wrong-headed for the rights of existing landowners. And one has to ask, why would you want to do this with the gem of Northwest Arkansas, the Boston Mountain Scenic Loop, Highway 74 out to Devil's Den, not to mention the other roads going out into the rural areas? Do we want sprawl, commercial sprawl everywhere? We've got places for that. We don't need more. Thank you for your time.
Public comments.
I'm Earl Allen. I'm presenting on behalf of Charles McKinney, who can't be here tonight. We want to thank you for your good service to the people of Washington County. You put their trust in you, and we want to request your support for revisions to the rezoning map and zoning text in order to protect the long-term beauty of our county. The existing single-family and agricultural zoning, which has protected us for generations, should not be swept aside in the interest of making development easier. The current proposals rezones both sides of every highway in Washington County to commercial. This will replace rolling pastures for us with pavement and commercial buildings such as those on Highway 412, east of Highway 71 in Springdale. Take a moment to visualize the effect of this being repeated in small communities and rural areas throughout the county, who most likely do not even know this is happening. The zoning map should be revised with more local knowledge. It should only rezone parcels where commercial activity is desirable, such as major intersections. It needs to consult local communities and designate parcels for all the zoning referenced in the ordinance, C1, C2, and industrial, so that people can plan accordingly. It should consider Arkansas Department of Transportation highway access points, scenic views, and adjacent uses, deterrence of suburban sprawl and development into areas such as lake and stream areas. The revised zoning map should be reviewed at local public hearings. Considering the zoning text has over 30 pages describing pavement and drainage, it is not unreasonable to request regulations that would minimize adverse effects, such as sign height and size, landscape buffer size and character for public edge and abutting properties, dumpster enclosures and placement. Lighting should have cutoff shields to eliminate glare on roads and adjacent properties, and should be reduced during non-operational hours. Stormwater detention is required to not contribute to local flooding and watershed pollution. Your leadership here will enable economic growth without sacrificing the beauty and vitality of rural communities. We ask you to table the ordinance until it is revised. Thank you.
Thank you, sir. Public comments. Guys, we can't have outbursts from the gallery. We're trying to conduct a meeting here tonight, so please respect that and let everybody have their turn and their time. Sir, would you like to have your public comments?
Yes, thank you. My name's Lloyd Keck. I live South Washington County, down County Road 216 near Bug Scuffle. Curious how many know where that is. Well, maybe more than I thought. I came to speak about the so-called zoning ordinance. So first of all, I'm a farmer. My son would be the 5th generation that's lived down in that part of the county on the mountain. And to the lady's first comments, I just planted 80 acres of clover overseeded, so trying to do my part there. I think people live in those areas because they don't want so much regulation. And I think this is an overreach, quite frankly, by the county. Certainly if this ordinance goes forward, as JPs, I think all of you need to look at that. There needs to be a lot of work done on the details and specifics of this ordinance. I'm currently not in favor of it as written, and I don't see that need. I think this ordinance probably is supported mostly by developers, maybe realtors, people that want to see that part of the county change. We live out there because if we wanted more regulation and details to our daily lives, we'd move into town where those kind of things happen on a regular basis. So I would ask that, one, you take a hard look at it. Secondly, if this ordinance goes forward, it needs a lot of work in language and changes. I'd say the public needs to note how their JPs vote on this. It certainly doesn't need to be rushed through on a second or a third reading. And I think the public in general needs more time and more information, notification about this, and I would encourage the county to look at ways to do that. I noticed signage going down South School. You know, I'm still kind of old-fashioned that way, but, you know, a sign down 265 south of West Fork on 71 and so on would probably get more attention because a lot of my neighbors don't have internet, don't own a computer, and the internet doesn't work if they did. So, you know, you can't forget that. Two other quick things. County Road 217, just past where you turn off to Bug Scuffle. I would like somebody, if they can, give me an explanation how the county chipped and sealed that road and then went down with some sort of machinery and tilled it back up again. That did not make a lot of sense to me. So with that, I'll thank you for your time.
Thank you, sir. We have about a minute and a half left. I'd entertain a motion to reset the time. Justice, 6 minutes. Make a total of 9 minutes.
I'll be brief.
Motion to reset to 9 minutes by Justice Pond. I heard second by Justice Hires. All those in favor? Aye. Those opposed? All right, sorry about the interruption. Let's continue.
Hi, my name is Tracy Slattery, and I live in southeast Washington County off of County Road 74, and I have lived there for about almost 30 years now. And I have a few questions and concerns about the ordinance. I'd like to know, are the areas being rezoned to commercial going to be zoned C1, C2, or either? And just point out that that means no building inspectors for any of those commercial properties, and that can present safety issues for people who are on patios or who are in those types of establishments that don't have proper building materials or safety materials involved in the building. How many elected people worked on the writing of this ordinance? The original ordinance, I know, took about a year and a half by 20 people on a task force to put together, and even after it was passed, it took about 2 years of amendments to get it to where it is today. So I'd like to know how many people did work on this and who. I'd like to know the rush. Why do we need to rush on this? Why does the judge believe we're in the 11th hour on this? There's a lot of people who are still trying to figure out what the map and zonings are. I didn't even get to see a final draft today. I hear that it's not out yet. And I think if it's a good enough ordinance to pass with this quorum court, that it would be a good enough ordinance to pass with the new quorum court in January that might be replacing some seats here. I would like to request that you follow rules in amending an ordinance and by highlighting the changes that you're making so that it make it easier for the public to see what the changes are. It's been said that the changes in the new ordinance will make the planning process easier for everyone, so the ordinance changes themselves should be easier for the public to process. I ask that no justice tonight pass this on to the first reading because we still don't have that final draft and the public deserves some time with it. It's an overhaul. It's a big overhaul of what we have in existence right now. And I think it's important for all of Washington County citizens to have some time to look at it because it affects all of us. I have a question. If someone has a use for a commercial enterprise near me and in an agri zone that's not going to be commercial, that's agri, single residential, and they get it changed to commercial, and say they get a zoning of commercial and they change their mind for the use that they had, can they still do something with that property under the new zoning that they have, or do they have to go with what they came before the council for to get the zoning in the first place? That presents some problems. And also, if a property is rezoned to commercial to the left of me, would that set a precedent for any other property near me?
Thank you, ma'am. That was 3 minutes.
I
Time's
have more to
expired.
say,
Next
so
public
I will.
comments, please. Sir?
How much time do I have, sir?
3 minutes.
3 minutes, thank you. So you've heard all the...
Please state your name and where you're from for the record, sir.
Jerry Jans from Bug Scuffle, Arkansas, neighbor to Lloyd Keck, apparently not affected by this proposal, thanks to a lady named Kendra, and because the website was down, I actually called the office, and this young lady educated me, and her supervisor manager, Sam, was right there. I hope to get to meet him tonight. So information is available to understand how this proposal is supposed to work. So you've heard all the legal reasons and documents and papers that people have about why this is an issue. But an emotional reason is much, much better in my perspective. So
You know, I have this whole thing that I wrote out in 30 minutes to talk to you. Like Lloyd, we've lived in this community for generations. My wife, family has. I've lived there for 45 years. And there's a reason that we live on the very furthest outskirts of Washington County. I mean, we literally own property on the Crawford County line. So we're not impacted by this proposal, but it's just miles down the road, which means the encroachment will eventually get us. And there's no need for that. There's a reason that in 2007, the CUP was enacted for landowners to have an argument about some non-land use regulated entity coming in to disrupt the environment or the community. What I was told by the very educated staff there was that it's, instead of 1, 2, 3, it's now 3, 2, 1. We're just gonna do it backwards. Why do that? If the process for the conditional use permit has worked since 2007, then why are we enacting policy that reverses that? And that's my understanding. And this young lady, we literally were on the phone for 35 minutes for her to help me understand the process. So why is this policy being enacted to create a red line that runs down places that are zoned agricultural that have nothing to do with commercial entities or residential developments? I mean, I've lived here for 45 years. Prairie Grove, Farmington, places in Lincoln, I have harvested.
Thank you, sir. That was 3 minutes.
Seriously.
Absolutely.
All right, thank you, sir.
Public comments.
Sherry Main, 15451 Richards Road, Fayetteville. I want to comment on a couple of things first before I get into the zoning. So I want to thank the judge and Attorney Lester for starting the enforcement on Monica Terminella's dirt pit that's adjacent to the original Weddington mine. And that's ongoing, I guess, filed in court. And I've recently learned just last week through the FOIA from the ADEQ that the intent of the property on the original Weddington mine that's adjacent to the Sailfish LLC Monica Terminella's dirt pit, the intent has changed on the property according to the ADEQ records and what was submitted for the new application for this mining permit and the stormwater, industrial stormwater permit. It's not any longer greenhouses and hemp or strawberries for agricultural use. The intent now has changed to reclaiming that to pasture. And this doesn't substantiate an agricultural exemption because most reclamation on red dirt pits and mines and quarries and anything where you take the fill out is the reclamation is done for pasture. I mean, that's just a given. So it doesn't fall under that agricultural exemption. And I'm just asking that you revisit the original Weddington mine agri exemption for this purpose to fall in line with the new application applied to ADEQ for their mining and stormwater, industrial stormwater permit. And I also ask that you revisit the Hillside Quarry red dirt pit. I found also through my FOIA with the ADEQ that it remains on appeal in litigation, but it is under the same agricultural exemption as allowing them to operate a commercial dirt pit without a cup. And the intent of that property is as well for pasture. So after the reclamation, I feel this is a smokescreen in a gray area, and we need to revisit these and get these fine-tuned to meet the criteria of the zoning laws we have now in effect, which are not being enforced. The county residents on Greenboro Road are choking on the dust caused by this dirt pit. They need dust abatement now. It's the county's responsibility, the road department, for dust abatement on county roads that is endangering or damaging the health of the citizens that live along that road. And there's no accountability for Hillside owner Bobby Morris for this. And on the zoning, I would just want to say we need to look back at ACA 1417-207, the state code, as to if there's any amendments, revisions of the zoning proposed, then it needs to go back to the
you, ma'am.
planning
That's
for
time.
a public meeting.
Yep, and our public comment period has expired unless we have another motion. Justice Lyons?
I move to extend it 3 minutes.
I have a motion to suspend the rules and add 3 minutes by Justice Lyons, second by Justice Pond. All those in favor? Those opposed? You have 3 minutes, ma'am. Thank you.
Good evening, everyone. I'm Roma Gray on Harp Road in Fayetteville, and I'm here to express grave concerns about the rezoning proposal. This blanket overlay of commercial zoning along all state highways, in my opinion, is irresponsible, and it exemplifies bad land use planning. This would contribute to suburban sprawl, damage to the environment, the rural aesthetic, tourism, and livability. Safeguarding the natural resources of the county is one of the things this court is charged to do. These state highways are scenic gateways to the Buffalo River, Beaver Lake, War Eagle, Hobbs Park, Lake Weddington, Devil's Den, the Illinois River, the Mulberry River, Natural Dam, among other beautiful natural places. This plan would affect thousands of acres along highly visible mountain, valley, and pastoral roads. A rezoning plan of such grave importance to the benefit of this beautiful county deserves extreme forethought and scrutiny. It should be carefully evaluated by rural planning experts, environmental experts, hydrologists, and traffic engineers. Have you all driven all of these roads to imagine the future impact of this plan on curvy, mountainous, poor traffic visibility roads, and the impact of big delivery trucks servicing the commercial zones on these highways? Have you inventoried the natural and cultural resources within all of these parcels? Have you obtained environmental, wildlife, and hydrological studies? If not, why would you saddle future generations of Washington County with potentially disastrous consequences? What is the rush on pushing this ill-conceived plan through? Please vote no on this current rezoning proposal. Let's take a long-range vision for this county, its natural beauty, its rural aesthetic, tourism, and livability, rather than a short-term plan to allow uncontrolled economic development for a few at the expense of its citizens and irreplaceable natural resources. Let's get this right instead of just getting it done.
Thank you. With that, our public comments have expired. I have a motion to suspend the rules and add 3 minutes. Who else wants to talk? Is there anybody else aside from this young lady who'd like to talk this evening? Okay. Can we please line up so we know how much time we're wanting to add here? I have a motion to suspend the rules and add 9 minutes by Justice Pond. Justice Lemming, does your second still stand? Second by Justice Lemming. All those in favor? Those opposed? You have 3 minutes, ma'am.
I am Kendra Reister of Devil's Den, Winslow. You guys, I don't think have thought about how that's going to affect the park and the wildlife. That corridor butts up on both sides to the National Forest and the park. Big part of that's wildlife conservation. There will be light pollution. The bats won't be able to hunt properly. It's just really important that you take a look at this because we live out there because it's beautiful. And it won't be anymore. Thank you.
Thank you. Public comments. You just turned it off. Will you hit that button again?
Which button do I push? Oh, okay. Stephanie Foster. I live in Fayetteville. I have property out in the county, in Washington County. I think we've heard a lot of good concerns from citizens. I hope you all take them to heart. I have a comment more about the process. I think I heard in one of the meetings that someone asked for a comparison of what the old process was and what the new process was. And I don't know if you all have been given that, but I don't think it's available for the public. And that, I feel like, is really important. If not that, I know that could be very difficult to put together, but if you know the process, I mean, if you know this document, you put it together, you should be able to do that. But I also think a flow chart. What are the steps? Step one, if you want to put something in that you're not zoned for, step one, step two, step three. What if it's a mine or a quarry? Step one, step two, step three, so that we as citizens who know how the old process works can see how it's changed. And then we can come forward with some educated arguments to discuss and let you know how that would be problematic for those of us who have property out there, who live out there, who drive those roads daily. So, thank you.
Thank you. Public comments.
Good evening. I'm Jim Norwood. I live at 885 Dairy Farm Road, West Fork, Arkansas. I've lived out there about 50 years now and have no neighbors adjacent and so it's been wonderful living that way. I was 27 years old and I built a 2-story log house by myself for about 3 years. And I've lived in that house all these years, and so I'm looking at this zoning, and I'm looking at the zoning ordinance about building codes. And so we're talking about the zoning ordinance shall be observed through denial of the issuance of building permits and use permits. It shall be unlawful to erect, construct, reconstruct, alter, maintain, or use any land, building, or structure in violation of any ordinance of the County Quorum Court. Now, there's a lot of people out there that can't afford $350,000 starter homes, but they can move out into the country and build themselves a house by themselves. I mean, I'd never built a house before, but I built it for $17,000. It's worth over $300,000 now. And so obviously I didn't screw up too bad. And so I'm wanting to protect that for other people, for young people that can't afford the starter homes, that can still move out in the country and buy a couple acres and build themselves that little house of their own and get started. And I think that will help solve the housing problem in Washington County. This is making me a nervous damn wreck being up here. So I'm sorry you guys had to put up with this, but I wanted to get that out. So thank you.
Thank you, sir. I appreciate it. And with that, we're going to move on with our meeting. Next up are the approval of the minutes. I believe the minutes were emailed out with your packet. I'll entertain a motion to accept the minutes. We've got a motion to accept by Justice Dean, second by Justice Lemming. All those in favor? Aye. Those opposed? Thank you. The minutes have been accepted. We'll move on to the judge's report. Got a lot going on in Washington County of late. I want to thank again the Master Gardeners of Washington County for providing us with the snacks this evening and the hospitality. We always appreciate them. I want to highlight that the disposal report's in your packet. Update on our CSU progress. We are going to have a full architectural presentation to you guys at our next County Services Committee, which I show to be on the 30th. So there'll be a full unveiling of that. They'll have some 3D renderings so that you guys can understand and see what we've been working on, and I invite the public to get involved with that. That's probably the most consequential construction project that Washington County's had in some 20 years, and so that'll be an incredible opportunity to support our first responders and our first responders and all of our emergency management team with that new facility, and so we're really looking forward to that and really excited about what the future holds there. We've been working on a new compensation plan, which I know you justices have been hearing, and we've been doing some employee meetings this week for some Q&As to try to answer questions for the employees and address any concerns they have. We've gotten really good feedback with that, and I think we're on the right track there. Comptroller Sherman said today that sent out again or an email reminder saying that we should all try to look at our budgets and make sure that we can try to accommodate that if all possible. And we're a little bit over what our planned cap was, and we need to go back and sharpen our pencils a little bit. So we hope to have you guys a final budget summary with that comp plan so that you can start looking at the global numbers very, very soon. I want to say that we had the opportunity. I am sorry. I've had a long day today. We've been to Little Rock and back, and I'll address some of that in a minute. It's not the CSU. I'm sorry. It's the EOC, the Emergency Operations Center. that we're talking about. So that probably injected a lot of confusion right on the front end of that. It's the Emergency Operations Center that our architect will come and bring those 3D renderings with the details and the budget and all that kind of stuff. We have a final product there. Apologies for my confusion. I and my leadership team had the opportunity to visit Genesis Church this week. And I want to say that I'd heard a lot of rumors and accolades about those individuals down there. And what I'd like to say is they're walking the walk. They have some incredible programs down there for the community. It was great for us to get to see that and learn more about it. A couple of them that we'd highlight is Micah's House Ministries, which operates as a transitional housing for people in drug treatment and rehab, and they're doing some phenomenal work there. But they also administrate the Fayetteville Pick Me Up program, the trash pickup program along the Fayetteville trails there, where we're hiring individuals who are displaced to do that work. And we got to meet some of those individuals doing that at their lunch break the other day, and it was phenomenal to see them, and they're doing some very uplifting work there. And so hats off to them. You know, as we continue to look at where we want to move as a county in terms of justice and things like that, I think they're going to be instrumental parts of that. We see a lot of phenomenal resources around the county that we need to just string together and make sure that we're all pulling the cart in the same direction. And I have no doubt that we're going to do some phenomenal things in the next couple of years. Looking forward to work with each one of you individuals on some of those plans in the very near future after they become more in focus. I had the opportunity to go to the Electric Cooperatives of Arkansas broadband event this morning and talk at the Capitol. The state's announcing through the state leadership and the state legislature that they're going to invest $1.6 billion in broadband across the state over the next few years. My part in this was the opportunity to go down and really highlight and appreciate our relationship as a county with Ozarks Electric, but also now Ozarks Go. And what I wanted to highlight there is, you know, Ozarks Electric has been an incredible part of this county's history and its progress. I think they are very much to thank for any of the progress we have in this county, not, closing that divide back in the 30s with people with electrical power, making sure that the quality of life has risen for all of our county constituents, and all those skills and all those expertise that they developed in bringing power to the county. When the broadband issue came up, they put those to work through Ozarks Go right into that mission. And what I'd like to say is, by and large and comparatively across the state, Washington County has great broadband coverage. And what I wanted to say, my viewpoint from that as a county judge is, I love the trust that we have in Ozarks Electric and Ozarks Go, that they've been part of our community. They're community owned. They're our fellow Arkansans and our Washington County citizens, and they give me a lot of trust that if we have issues, they'll be there to help us. They'll work shoulder to shoulder with our first responders to either fix the infrastructure and make sure people are back safe. And so I just want to once again, I had the opportunity to Capitol Day, but once again to thank Ozarks Electric Cooperative and Ozarks Go and all the phenomenal work they do around our county. We are very blessed to have them here. I believe Justice Rios Stafford sent out an update this today about the USPS, United States Postal Service facility, the sorting facility there in Fayetteville. You know, last year we were very concerned. We'd received word that might close and those jobs might move to another state. I want to thank Justice Rios Stafford for taking the initiative. We've passed a resolution for here at the Quorum Court to support that facility staying here, and it looks like we've gotten some traction there and that the facility will stay in Fayetteville and actually have some additional funding attached to it to maybe improve that facility and put it here in our area for a long, long time, and so I appreciate that. A couple of employee recognitions that I want to give out today. Tad Sowers, our communications director, received his Public Information Officer credential through the Center for Public Safety and Excellence. This is an initiative that Director Sowers took on to continue his education and continue his certifications, but also to make sure he has the skills to do his responsibilities here to keep the people of Washington County informed, not only through the regular business of the county, but what might be emergency situations in the future. You get that by attending classes, taking tests, and then also Mr. Director Sowers had to vouch for his on-the-job training, if you will, his work experience here. This is the 46th designation given internationally, and Director Sowers is the first in the state of Arkansas to receive this designation. So, Director Sowers, I appreciate you, sir. Next up is our Emergency Management Director, John Luther. John Luther, they had a conference a few weeks ago, and he received the Glenn Sonny Cox Award for Excellence in Public Safety Communications. Big deal with our state. What I want to say is John Luther, Director Luther, has been part of our community and our county for his whole life, going back generations. He's passionate about the people of the state of Arkansas. He's passionate about the people here in Washington County and keeping them safe. I really appreciate having you here, Director Luther. And what I want to say is this award is absolutely well-deserved, not only for his lifelong work. The award tries to pick individuals who not only have a lot of expertise, but share that expertise and collaborate with their peers across the state. And that epitomizes what Director Luther stands for. That man has always been willing to share information and help others. And so what a well-deserved award. I'd like to also point out well-deserved because, last October we moved to the Arkansas Wireless Information Network, the digital AWIN system. John Luther and his team oversaw that transition, and we all know that we've seen incredible success from that. So Director Luther, thank you so much for all your efforts here in Washington County and a well-deserved recognition from the state. And comments for both of those individuals, but more importantly for the rest of our workforce, is we're leading the state. We are leading the state in our respective areas. The other areas around the state are looking to us to see whether it be broadband coverage or our PIO or the radio network that we're ready to establish. We are now being asked as other counties to be a resource for them, walk them through our trials and tribulations so as maybe to help them. Guys, I feel the Lord stirring in our group. I feel the Lord stirring in our county, and I rejoice in that. And with that, let's move on to the business of the county. First up is item number 8. It's the consent agenda. Counselor, will you read those items by title only?
Item 8.1, an ordinance de-appropriating surplus amounts from full-time salaries for various departments and restoring to unappropriated reserves as required by the 2024 budget controls for the second quarter of 2024. Item 8.2, an ordinance projecting revenue and carryover totaling $78,715.70 in the Veterans Treatment Grant and appropriating said amount to the Veterans Treatment Grant Fund for 2024. Item 8.3, an ordinance amending the IT budget for 2024 and for other matters pertaining thereto. Item 8.4, an ordinance amending the Circuit Court 8 budget for 2024 and for other matters pertaining thereto.
Justice Lyons?
Thank you, Judge. I move we pass the consent agenda.
I have a motion to pass the consent agenda by Justice Lyons. I heard second by Justice Dean. Any further discussion by the group on any of these items? Any public comments on the consent agenda? Seeing none, Mr. Allen, will you please call a roll? This is the motion to pass the consent agenda.
Justice Taylor? Yes. Yay. Justice Wilson? Yes. Yay. Justice Bowerman? Yes. Yay. Justice Lyons? Yes, sir. Yay. Justice Ecke? Yes. Yay. Justice Dean? Yes, sir. Yay. Justice Washington? Yes. Yay. Justice Coger? Yes. Yay. Justice Dennis? Yes. Yay. Justice Hires? Yes. Yay. Justice Rio Stafford? Yay. Yay. Justice Lemming? Yay. Yay. Justice Ricker? Yes. Yay. Justice Pond? Yes. Yay.
The consent agenda passes. That'll move us to item number 9. Counselor, will you read that by title only?
An ordinance creating new planning and zoning law in Washington County and for other matters pertaining thereto.
Just before we get started on this with the questions and debate, I have a couple things. We understand that tonight Counselor Lester had an unexpected absence. Actually, he had one of his sons have an injury. Everybody's fine, but of course those things come up to an emergency for us. I want to address a couple things just so the public can be put at ease. We've tried to take this process very slowly. We're gaining input from the citizens. This is a work in progress. We understand that. I don't think anybody has intentions to sit here tonight and try to railroad this through, which has been some of the accusations. I'm sorry if wherever we got that insinuation, that's not my intent. I don't think it's the intent of the court. What I will say is that there are changes to this ordinance regularly right now because we are getting comments, we are gaining feedback, and we're trying to incorporate those the best we can. What my suggestion would be this evening is that we let Director Atta bring us up to speed of where we're at with the ordinance kind of the final draft where we're at right now. We've made notes that the map is not worked on the website. We will certainly try to take care of that, and we'll try to continue to take these comments and questions and field them. And I think with the absence of Councilor Lester here tonight, and of course the work we want to continue to do with that, I would suggest maybe that we postpone this a month after we hear a little bit more about where we're at, so that we can at least be brought up to speed and continue to carve on this. I had no intentions tonight of the Quorum Court moving this forward. I don't, any of you that I've had side conversations with about this, I don't think that was anyone's intention. So I apologize if the public got that insinuation from any moment. We got a few JP comments, and I'll start rolling through those as they've come in, and then we'll let Director Atta. Justice Ecke?
Thank you, Judge. As a way of suggestion, I think what put a lot of people on pins and needles and things came out, and you better not vote for this, is that it was an ordinance creating a new plan. And anytime I think our constituents see an ordinance, they think it's either going to be passed, suspend the rules, and moved forward. And is there any way that we can just amend that moving forward until we have a final ordinance to put a proposed ordinance intended to engage our community and all stakeholders? In other words, just rephrasing what the intent of the court is, because I don't know about my colleagues, but everybody's response or emails and text messages were almost panic. Are you really going to vote for this tonight? I said, no, 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 no. And so I think the best way we can put everybody at ease that this is a discussion is if we can just rephrase what the intent of the ordinance is.
Yeah, and I'll say what I've been doing is relying on our parliamentarian to know what we move in front of the court. We'll definitely take that comment down, and I don't have a great answer for you tonight with Councilor Lester out, so we will try to get back with each one of you about that, if that makes sense. Justice Lyons?
Thank you, Judge. I think the biggest gap is the map doesn't match the ordinance. I think I looked at the map. What was it, Director Atta? We sat down and looked at it. You helped me out about 2 weeks ago, 3 weeks ago, something like that. And it's all shown as commercial, right? Whereas our ordinance, it talks about C1, C2, and industrial. So there's a lot of questions around that. As you stated, sir, there's making changes based on comments, et cetera. And I think there's even some more changes coming around about really what we're going to do with this, how we're going to work this based on commercial, C1, C2, and industrial. Sure. I think with all those unknowns and all those questions, I move we send this back to committee, work on it still in committee instead of in the court. Let's use the court for the things we need to do to continue business. Take it back to the committee. Let's continue the discussions, bring comments from the citizens, bring the changes that Director Addit and Councilor Lester is bringing to us, identify and let's get the map to mirror what we've got in the ordinance, and then bring it back to the court for a vote. So I move that we take this back to committee.
I have a motion to move it to committee by Justice Lyons. I heard second by Justice Coger. Mr. Allen, will you please call roll on that? This would be this is a motion to refer this ordinance back to committee. So, County Services Committee, can I take that liberty? We'll refer. Would you, County Services Committee, can we just designate?
Yeah, that's where we came out of, right? So
yes, sir.
That's where I would think it was.
So I have a motion by Justice Lyons to refer this back to committee, the County Services Committee, and I heard second by Justice Coger. Is there any comments on referring it to committee? Justice Rios Stafford, did you have comments before we take up?
Yes, I'm in favor of that, but just a point of clarification. If we vote on this right now, will we short circuit our ability to hear the presentation?
Yes.
Okay. I would prefer, me personally, I would prefer to hear this presentation before we make a motion to send it to committee, even though I am in favor of that.
Make a motion to amend.
Justice Lyons?
I'm fine with pulling the motion back for now. I'd love to hear what Director.
I think Justice Lyons has agreed to withdraw his motion for now, and he'll remake the motion after we have some discussion and some presentation. Does everybody think that's appropriate?
Yes.
Okay. Justice Taylor, did you have something to comment on before the presentation? No. Okay. Director Atta, I believe the floor is yours.
Thank you. So it's not presentation as much as thanks for everyone, public, JPs, everyone, for like sending the feedbacks and the questions. We're working diligently on like just addressing all the issues. And like, as I said, like maybe years ago, like feedback is a gift, and like we totally appreciate it. So I need to show like few stuff, like the misunderstanding. Some of the JPs who worked on this back in 2004, 5, and 6 to be approved, some of them are still here, and they're sitting here. And the most likely they know that the biggest change is just like the zoning, which is eliminating the CUP process to make it like more streamlined, coming to the quorum court first, and then going back to the planning board. So let's say like we have like A and B. So let's say if this passes, and like we have an area that's already zoned and one is not zoned. So like you're like A, it's already zoned commercial. You're gonna come and ask me and say, or call the office and say, hey guys, like I need to do this business in this area. We're gonna say, hey, what's your parcel number? He's gonna give us the parcel number. We're gonna check. It says like, hey, you're in luck. It's like zoned commercial already. So the next step is to go through the planning board process. The planning board process has not changed. So it's gonna be the technical review. It's gonna go to the engineers, all the stakeholders. It's gonna go to the road department, health department. We get feedback. We do everything, notify the neighbors, and then bring it back to the quorum court for approval. So if you're like in zone, like in area B that is not zoned commercial for any business, the first thing you have to do is apply for rezoning through the quorum court. I have this like tiny graph. I apologize. I just like made this before coming here, so I don't have like a copy of it. But like I'll be happy to email it to everyone. So basically, you come to the quorum court through application. We collect some information just to make sure like your like area is viable to go through the zoning process. 21 days, you apply 21 days before the quorum court meeting. 14 days before the quorum court meeting, we send the neighbor notification. And then if everything passes through the quorum court, that project goes again back to the planning board process. Same process I just mentioned. If it does not, the applicant has two options. He either come back and reapply with a new scope of a project scope, because like it wouldn't be a great idea to reapply again with the same like project because you know it's already gonna get denied. Or you can take it to the circuit court and appeal it there like and fight it. So that's the whole thing. So if it's zoned, it's great, goes to the planning board. If it's not, you rezone and then go through the planning board. Everything goes through the planning board for approval. We have conditions on all projects. Still the same process. One of the questions I received from JP Stafford about notification, that's one of the biggest changes we're gonna do. And instead of like our team take care of this, we're gonna have an affidavit we give with the applications, ask the applicant to go through the process. As a team, as a planning team, we're gonna provide them with the map, the neighbors that need to be notified, a list of everything. They have to go ahead, and even we're gonna provide them like with the template of the letter that needs to go out. So they have just basically go ahead like and print out, mail the notification, bring us a proof that it's being mailed by the deadline, and we take it to the planning board. If they miss the deadline, basically we're gonna say, hey, you missed our ordinance, so we'll see you in the next cycle. So the same thing. And this example like from the old ordinances, and that's why we're consolidating everything in just like one document, because it's like a mess, seriously. You can see that's like one section of the old ordinances just for notification. We have a bunch of ordinances, like one is built on the top of the other one, amended from the previous one, amended from the previous one. So that's how it's gonna look like here. Everything is included like in one section. It's gonna be one ordinance section, step 1, A1, A2, A3. So that makes life easier. That's for instance. If you look on our like website and see the ordinance code for the planning, this is how it looks like. So you have to read each one of them separately individually to be able to get, yeah, that's the one talks about like septic. And I don't think this is like very efficient. I get lost in it, but I'm glad like I have all of them like sectioned, like and named, I spent like years on them. So that's why we're doing this. That's part of it. Makes life easy. So some of the changes, as I said, we received from the public is the confusion between like, the conditions and the conditional use permit. So we eliminated the word conditional use permit. As I said, each process goes to the planning board, will come with conditions to make everything compatible with whatever looks surrounding. So I'm pretty sure like Mr. Maynard knows how this works. So if it's being zoned or not zoned, if it's a subdivision or not a subdivision, it's a large-scale progress or not, all of them needs to go through the planning board so we can do the conditions. They're going to be reviewed by our engineer and everyone else, same process, and they will come back before the planning board for yes or no. So, see, that's the only change. It's like the conditional use permit becoming a rezone. Everything else, exemption, subdivision, minor subdivisions, large scale, it's still the same process. Everything's still the same. It looks, maybe it looks intimidating because it's like one big document, but if you look at the old one, and I can email it to you, you can look it over and it says, oh yeah, that looks way much better. I can email you this tonight if you want to. If not, if you can wait until tomorrow morning, I'll do it tomorrow morning. We had some technical difficulties because like it's not ours, the map was working fine. We had like a firewall like issues and it being fixed today. That's why you will be able to access the zoning map. Anything we do, Brian and I, we fix everything, we update, we create like a new draft, compile everything, and we post it here. So that is not the one right now, is not the latest because we have not finalized the one. That is like basically what you're gonna see soon. See, the conditional like use process, we eliminated all of this, we fixed all of this to say like procedures, and as I said, like everything that is not necessary makes any confusion. And I've seen this, and I'm pretty sure like members of the public says like, yeah, I sent him that. So, so we're working on this and fixing all of this. Hopefully it's gonna get done like soon. Work in progress. We have to start somewhere. Just like be patient with us, and it's not an easy task. That's not what I do 90% of the time. We have like daily operations. We have 14 projects for like next week, and tomorrow is like we have to submit all the staff reports. So it is like tedious work. Any questions?
I'll address some questions that I continue to get. It seems like they're plentiful. First of all, we have a zoning process right now. And in my mind, it's one of the most egregious oversteps of government I've ever seen in my life, because what we're doing is we're denying the small business owners, and it seems like inevitably the big businesses and the industrial businesses make it through. And either they do that or they don't abide by the law, and that's becoming very frustrating, and I hope as citizens you can understand that from our point of view also. One thing I've been asked a lot is, this will not change your property taxes. This has nothing to do with property taxes. We've confirmed that the assessor's office understands that what happens is your property taxes are based on the use of the land. So this will not affect your property taxes at all. A couple other ideas a couple other concerns I've heard. What if this is zoned commercial and I want to do something different with this land if it's zoned commercial? Agricultural and single-family residences are a condition by right. Those will always be within the purviews of the Washington County citizens. We're not wanting to get into that and get into that area at all. So this will not affect you if this is zoned commercial and you still want to use it for agricultural. So just a couple.
Can you restate that, please?
Yes.
So if it's zoned commercially?
If it is zoned commercial.
But you are
agriculture. But you would still like to use it for agricultural or residential. That is always a condition by right within our Washington County ordinances.
So is that in general, anything less than the zoning is permissible in that zone?
Yes, sir.
Yes.
Yes, sir.
Yeah, thanks, Judge, for reminding me. So we're going to have basically three categories. We're going to have residential agricultural by right, which is still there. We're going to eliminate the C1, C2 because it looks like it's very confusing. We're combining them all together into like just commercial use. And then based on the criterion, goes to the engineers, and the engineers will come back, says like, this is what we need to do, this is what we have to add. The third one is the industrial, or like the big high intensity projects, which so far we have not seen anything like newer than like what we already have. So we're not creating any industrial as much as we just expand. We had some project that expanded on what exists. So we're gonna have that like three: commercial, residential, agricultural, and industrial.
And back to the map, there was a question, I
Yes.
believe, one of the Justice Rio Stafford's questions was, these industrial areas that are now listed on the maps, those are industrial areas that were grandfathered in?
Yes, yes, sir. And once again, let me remind everyone how GIS work. Anything you see on this map is attached to a table. So all this information comes from like a table that's already been processed through like our planning database, or anything we can get like from the assessor's office. So for instance, if any of you guys like had the project prior to 2006, you're not gonna see it here. You're gonna call me and complain. So it's like, well, I have a business that's been here like since the 90s. Yes, sir, I cannot add you because I don't have you going through our process, so I don't have you on my database. What you see here is what's being approved, went through the planning board, or like went through the planning office process.
What
So
we have documented record for.
everything is documented. Like there is, I mean, where do you think I'm gonna get this data from? That's, yeah, everything we have here is documented. Everything we have posted.
Well, and
have
I
Excel
just
sheet
want to make
for.
that very clear to the public, because I think there's, this is an emotional subject. There's a lot of times a lot of distrust in this. There is no industrial on that map that was not grandfathered in. We are not trying to create new industrial zones with this ordinance. That is something that will be up to you as the quorum court. This will be a living process that will have to be managed over the next few years. Justice Rio Stafford, do you have another question on that, or? Sorry.
Thank you, Judge. Yeah, just, since we had the planning board had their public meeting, and the public was invited to give questions, and it was publicized in the paper, we've had a lot of constituent feedback, because I just think there's been a lot more awareness. So more questions from folks have come up, and earlier today I wrote out some of these, and thank you for getting a couple of these answered already. One of the other ones was, and I guess I was unclear on this, in the original draft that we saw, there was a C1 and a C2,
Yes, ma'am.
and the map only has one type of commercial
Yes,
zoning
ma'am.
on it.
I want to speak to that.
Yeah.
We were not trying to incorporate, I think our intentions, from my point of view, and Director Adda can certainly chime in with his, we were trying to get the process started and give you guys C1 zones to start with, and then C2 could be incorporated later on, since that's a heavier use and harder impact. We were not wanting to do that on the initial zoning, but now I think Director Adda can have some comments on that, and also he's just said that we've
Yes,
taken
sir.
we've taken some feedback, and we're
Yes, sir.
incorporating just the one commercial
And
zone. Director
besides,
Adda?
besides the feedback we got from everyone, like the reason we eliminated all of like the C1, C2, because even in the previous code like we had commercial, light commercial definition. And the light commercial definition is basically that's something that is like a buffer between the industrial and the residential. So we've never had anything that like really industrial. We've never had any, since I've been here, we've never had any factories coming to the county. So it's like, hey, I'm gonna establish a factory in the middle of nowhere. The only like big project we had is like the quarries and like the mines. And the only reason we did this because they purchased the land around them or next to them, and they expanded on them. So nothing you see here that hasn't been through the planning board process. Everything you see here that is highlighted went through the planning. Anything you see is not highlighted and say, I know this is a mine, yes. That is definitely being grandfathered in, or it's being before that, before the whole zoning process. So nothing strange, nothing new. Everything we have here, like it's documented.
Sorry. Justice Ecke?
Thank you, Judge. A question that came up, and it had to do with the agro-residential. if a farmer is agro and has got some cattle, but this year it just rained and rained and rained. So he was able to bale a lot of hay. And if he wanted to sell hay out of his barn, is he have to come out and get a commercial?
We've never asked anyone who's doing commercial, and that's part of the definition. Anything it's related to commercial is commercial. Like bee farm is a commercial. Like
okay, so if you
goat
already
farming is a commercial.
Wait a minute. Agricultural.
Yes.
I want to make sure you're not switching commercial.
No. It's agricultural. It's like we've never. So anything that is related to agriculture stays agricultural.
I think he was using commercial. When
Okay,
he, well,
I
just
think he
while
did.
anything related to agricultural
It
is
stays
agricultural.
So if you're selling for commercial that is related to agriculture, it's still agricultural.
Okay,
So
the
selling
answer
selling
is,
hay, selling like goats, anything.
A large, onto my, add to my hay barn and
Mm-hmm.
sell farming, are my neighbors gonna get mad and turn me in and say, I don't have a commercial license? So that was the question.
It's the definition of agriculture is like very obvious. So you
Okay.
can, same as like people like who have heifers and like they're like producing cows and like they're selling them. It's agricultural related.
Okay.
Same as someone like who's having bees and selling like honey. It's the same thing. It's agricultural.
And I think it's
Okay.
a great example.
Thank you.
If you are agricultural or you're zoned commercial, you can still do your agricultural activity. Nothing changes. Your taxes won't change. It's the use of the land.
Yes.
Justice Heckey, did you still want the floor?
Oh, no, I'm sorry.
No problem. I thought you were
That was
looking up
just-
another question.
I'm just, no,
I know,
just, well, let me see if they've got another question. Oh, the other question is, say we zone and pass all of this, what if Fayetteville or any other city starts annexing? What's to stop them
That's a
from
different
annexing?
process. Like annexation, most of the time they annex. That's from what I've seen. They annex subdivisions because like they already like built to the road standards that they are like asking for, and most of annexation goes through like voting.
Yeah,
So
but we don't have a vote on that.
Not us.
It's
like-
always the city who just
Yeah, so
kind of strong arms and
that's something. It's like
that's
way,
a
way
big
above what we're doing.
concern.
And I would say
So
that
who gets the taxes then?
the county judge has very little authority in that also.
Yeah, I know.
So by state law. So
State,
that's just
yeah.
I don't want to disregard it or minimize it, but it's kind of a sunk cost.
So all the businesses, say, the commercial, that get started and cities want to annex those commercial properties, they now get the sales tax.
As the state law stands right now, they could absolutely do that and it would be well within their authority. With
We
very
need to
little
do
protest or intervention from the county.
They're very upset about that.
Yeah, and
No,
it's
I'm serious, that was one of the.
no, I totally understand, and it's not. Let's say like we had like one of the areas that's being annexed into Greenland. That's like used to say Fayetteville planning area, so it doesn't mean it's stuck with Fayetteville. Whoever can like annex it first and apply and do the process will take it first. So that's the nature
Okay,
of it.
let me see if I've got one more.
Cities grows like counties shrinks. That's everywhere.
Other than if you could clearly state, other than growth, I mean, my vision was always, are we a county prepared for and conducive to economic growth?
I mean, that's
Let's
what we've been
plan.
doing
And
for the past 20 years.
So they're asking me, why are we doing all of this? What changed that we have to do this? And I said, we're growing.
Yep, population.
Population.
Demand, lack of like land. It's like it's very scarce. So we're trying like just to direct everything away from like homes so that like people can just like have businesses in one
So
place.
land is scarce.
Very.
Okay.
Ask the city of Fayetteville, they will tell you.
Well, Springdale's landlocked.
Same thing.
So, yeah. I just wanted to be able to give a clearer answer other than we're growing. And with population increase.
Yeah, as a reminder, like this ordinance that like we have right now, active ordinance, it's almost 20 years old. And nobody does that. Nobody keeps that like running for that long. Cities or like even like bigger counties, they normally like update their stuff within 5 years. So it's always like a 5-year plan.
Yes. So now.
So we're past
Now we know
that.
how to answer more than just growth. It's a
Yes, ma'am.
20-year antiquated process. Thank you, sir.
Absolutely.
I'm done. Sorry. I'm sure.
Justice Taylor?
Thank you, Judge. A couple of preliminary comments. I try to sort of keep commentary to a minimum. Everybody else has a lot to say. I listen. Today, I listened to a group of people who seemed more impassioned, more educated, more concerned, and more engaged than anybody I've seen show up here yet. And I've, been here almost 2 years now. That I don't think is an accident, and I believe part of the reason for that is the idea, the concept of private property rights are so ingrained into our republic and so vital for continuation of any sort of relationship among each other as citizens, that any disruption of that, regardless of whether it be good, bad, or indifferent now, invokes a reaction out of people. And so to see people show up and to be as articulate and concerned and, frankly, have great points about every part of this is very encouraging to me, and is not lost on me because it is one of the most vital things that this society is built on. And so when you start messing with that as a legislator, as an executive branch, or some hybrid, you're going to get some reaction. And the reaction is not always going to be, oh, yeah, I agree, let's move on. The concept that the public misunderstood that we were not voting on this tonight, I don't get at all. I read it to say we were voting on a new law to be passed tonight. So that part is clear from the agenda. Second, the ordinance itself is, it's big. It's 180-something pages long, right? It's a lot to read, it's a lot to take in, and it's a lot to compare and contrast to the existing law. So the concept of a cheat sheet of like what's changing from the old law as it stands today to the potential new law, I mean, that's a big undertaking to do. I think it would probably hone in a lot of issues that everybody has instead of chasing, this 180-page document around. How we get there or don't get there is sort of remains to be seen, but I do think that's a good idea. Also, the comment that this looks like a copy and paste job from a bunch of other laws, I can tell you from behind the curtain, that's what lawyers do. So, whoever wrote this, that's what they did.
Oh, come on.
That's not necessarily a bad thing. From a specific standpoint, though, there are a lot of big concepts in this, and there are a lot of minutia in this as well that, how we get to the point of being able to look our constituents in the face and say, we passed this because, or we didn't pass this because, or we changed this because, there's a lot of technical stuff that's not going to be fun to go through. And so, relying on, Sam and his expertise and his office has been, a big help, and also the pros and cons of the way it's written now versus, what it should be or could be, or things that we as a legislative body have to flesh out. Otherwise, we just kill it as it is and say the law is what it is today and we don't mess with it. I mean, that's my view of it. There is no in-between. There is no Nancy Pelosi, let's read it after we pass it. I'm not doing that. And so, beyond that, just broad comments, I would want to, as a self-respecting attorney who would be asked to vote on this, not see abbreviations into our code. And they're like all over the place. I just noticed that.
I made sure like every abbreviation is like preceded by like the definition.
No, I'm saying like abbreviation, for example, of the word don't, of the word can't, that kind of stuff. That drives me crazy. Yeah. So I would ask that be cleaned up at some point. But as far as the concepts and the process, it's going to affect a lot of different people in a lot of different ways. And I think we need to have an answer to all of that, not just go ask Sam and he'll explain it to you after we pass it. And so that's my position on it, is that, it's in front of us now, and how we get to a final up or down vote on it, is up to us. But as it stands today, there's zero chance I was going to pass it as it is. But I think the concept of pushing it back to the committee and really fleshing it out until it is like final is great. So that's my.
Yeah, just let me clarify. I added about like 2 pages of this definitions on top of like the previous old like code. So that's by itself, it's a plus. With everything, all the tables we have, the text itself is like less than 100 page. What you see is the rest of the tables, the rest of like the stats, the rest of like the ordinances. From the previous code, we have all of this embedded as ordinance, see ordinance. So yeah, the previous one was maybe like about 100 page, but most of those ordinances, tables, and like graphs, they reference somewhere else, and so you have to go and look them up. And that's why you see it's like about like 180 pages. That's the reason we compiled everything, so to make it easy on the user.
And so that the public is aware, so that the public is aware of that. I mean, can you expound a little bit, Sam, on how many existing ordinances, I should say, are being affected by this and would then be replaced by this? Do we have that number?
I remember Brian referenced about like 60 plus.
60?
60 plus. And it's not like eliminated as much as like they're all like consolidated
Combining
into
them?
one.
Yeah, okay.
So, and that's what we're trying to do. And this process, as we mentioned before, started in 2018.
Right.
And we've been like finessing that like all those years. We have like lawyers who are not here anymore worked on this.
Mm-hmm.
We have previous administration worked on this. They're not here anymore. So once again, it's not something you can do like in a week or two. It would be crazy like assuming that. And we are trying the best we can with everything we have to produce something like useful, something that the public, even like in an easy language, can read and understand. They don't have to go to a lawyer to explain it. However, we can always like add those like
amendments
or hard like language
Yeah.
makes it like complicated. Oh yeah, that's great.
Yeah.
Yeah, we're not trying to do that. We're trying to make it as easy as possible. But if you have any suggestion, highlights, whatever like you think needs to be adjusted.
But from a public viewpoint, I guess, and property owner in the county, or some combination thereof, like the concept is updating the code currently, replacing maybe burdensome or cumbersome language that exists as it is today,
Yes, sir.
and improving on that.
It is improving. It's way much better than it used. I mean, I have the old code. I can email it like to each one of you and read it, and you're gonna like trust me. That is way much better than it was.
Right. But from a concept perspective, people hear, oh, the county's zoning, everything's going to be classified as either residential, agriculture. It already is. We know that,
everything
right?
in the county is like still like considered as residential, except for those strips that they're going to be like commercial, but they're still, you can use them as residential. Nobody's going to stop you from you, but it's by right.
Right.
Agriculture, residential, it's like the entire county.
Right.
This is just like we're giving you the chance to expand and like have more opportunities. If you don't want to do that, it's up to you. You don't have to.
Right.
Yeah.
But as far as what people hear, right, like the thing that lands on them is that in along these highway corridors, for example, right now, that property, unless it is, has a CUP in place, is by definition single family or ag, right?
Yeah.
And so the concept of moving that by default to commercial, I understand is alarming in a lot of different ways. And so how do we deal with that, you think, from a like literal where we draw the line perspective? I mean, what's the right answer?
Well, the
there?
only reason like we pick the highways because that's what we see growth going through. Like maybe 412, for instance, like 16 south. That's what everyone comes to us and says like, hi, I need to start a business. Everyone wants to be like close to like exits. Everyone wants to be close to a highway.
Right.
And it's actually like we have like 4 projects like in the next cycle. They're all on highways that like they're being established, and we have new ones that like they're potentially accessing the highway to go somewhere else.
Right.
So that's the only like access we have left. Most people like they own their properties and like it's either a subdivision or a farmland or it's owned by the state or the federal government.
Yeah.
And that's one of the things we eliminated when we started. Normally you create like a buffer and you tell the system, the GIS system, hey, go ahead, like pick everything that is parcel that falls within.
Right.
And then like, I had like lots of courses like, hey, I have a subdivision and my subdivision has a covenant. So I said like, yeah, okay, well, like we're working on it. So we removed all the subdivisions completely just to make sure if you have one or you're gonna establish covenants, you're not included. And if federal state government's being removed, anything highway like owned, we removed.
Yeah, you
Something
pull those
we have
out.
no jurisdiction over
Right.
to tell you what to do with your land, it's okay. I have people calling me, says like, I have this like protected and I have like a court order for it, it's being removed. So we're trying like as much as we move forward, like hear and fix. There is no way you can know everything happening in the county, what people do or like what's their intention for the future. Same way we don't know like that there's a business just started like 2 weeks ago until like one of the neighbors complained and says like, hey, they started a business. There is no way you can like fly over the county and says, oh, this guy doesn't have a conditional use permit or a permit to start with. It's hard. So it's a big county.
Do you know, sorry to interrupt, do you know how many, you made me think about something. Do you know, like, under the current map, how many actual parcels are moving to the default commercial? Like literal number?
I guess when I did the first time, it was about like 4,000, but it shrunk. And most of them is not like big, they're like tiny ones.
Yeah.
But they're shrunk like greatly because we start removing subdivisions. That takes about like 50 from each one of them. We have from 2006 until now, I guess like I sent Tom this, it's roughly 300 like 20 maybe.
CUPs
like conditional
in place,
use permits
yeah.
that have been approved. That's all gonna be compiled into like one
Yeah,
layer
it's like a
that says,
mass
like-
approval, right?
Yeah,
I mean,
it's already been approved, but it's gonna be like in a layer that says like historic, CUP approved as commercial. We're not gonna take
Oh,
this
that your
away.
grandfather,
Yeah,
yeah.
we're not gonna take this
Yeah.
away from you as long as like you've already been through our process.
Right.
Unless if you change like the use and like you wanna build a house instead of a business.
So the people that we see show up here normally for a CUP, for example, though, one that is not in a commercial corridor, that is in, you know, a remote corner on a county road, whatever.
Yeah.
Under this proposed ordinance, as it's written right now, the process to get what we now would call a CUP, it's a variance effectively under the new law. How would that change?
I guess like that's a question for Brian, but like most likely we were gonna keep everything that went through the CUP and is being approved.
No, I mean a new one, I'm sorry.
Oh, the new one? So as I mentioned like at the beginning of the presentation, so there is no conditional use permit.
It's a variance.
Yeah, no, it's not a variance. The variance is different. It's like you're varying from the code. That's a different process too. So think about like the new zoning as a reverse CUP. And instead of coming to us and ask for like commercial use and go through the planning board and then like ask for it to be, if it's approved or denied, you go to the quorum court for like ratification.
Right.
And we write you like, you approve it and he says, here you go, your CUP, you're like good to go for business. We're doing the opposite just to make sure that you as an applicant, this project is already viable and it's gonna start and it's gonna be approved for commercial use. So you don't spend tons of money on engineering and like, losing money on like just like lenders or stuff like that with the bank to keep like a mortgage for like a while until this process passes, and then like eventually someone comes with a deeper pocket and like make a big hoopla about it, and like it gets denied and people like loses like $20,000-$30,000. And we have lots of we have one recently. We had one about 2 or 3 years ago happened with like a gym. We have lots of people who lost money just like waiting for that process to be approved, and eventually like came to the quorum court and it was approved by the planning board, went through all the technical review, and they said no.
Right.
And that is just devastating for someone who spent tons of money and put like a second mortgage on his house.
Right.
So we're trying to eliminate this just to give you the assurance that if you go through this process and it's being zoned commercial, you are most likely going to go through the planning board with all the conditions they're going to put on you as expert or the planning board members. That is going to be approved. It's like a bigger chance than 50-50 chance.
Right, but something outside of the commercial zoned area.
Same thing. It has to be like really, really, really like substantial why you're not like doing this within that like
But we
zones.
see those.
Yeah.
We see those here, right?
Yeah, and like we don't want to do also spot zoning to a point That's what like the CUP is like looked at. It's spot zoning. Someone can like out of nowhere says like, I'm gonna start like my business there and then apply. We're trying just to eliminate all of this to, I don't want to say the word like force as much, encourage people like to stay within like those zones to make it like more like
Attractive is the word you're looking
it
for.
is like the beautification like act like JP mentioned like earlier, like it's there. So we're trying to make it more attractive, more appealing to the applicant. Says, okay, if I start a business here, my business is going to grow because like next door is a business, next door is a business. I'm not going to go and like, start a business somewhere next to a subdivision and the neighbors are going to say, hey, my value of the property is going to like be lowered or not. So we're trying like, to keep it just like contained as much as we can within like certain zones.
Right.
That's the whole thing. It happens in any city, it happens in any county. And like it's actually cities like they're more aggressive. They will have R1, R2, R3, like et cetera, and like they have C1, C2, et cetera. And like we're trying to eliminate this. We're not trying to be as aggressive as much as we're trying to be just regulate so everyone will be like uniform. So like you go through the whole process and everyone is expecting what the outcome will be, or at least what would be.
To make it somewhat more objective instead of the subjective.
Exactly. So we're like removing all the drama that when it comes to the planning board or the quorum court, go through a step. You have check boxes. You meet all of them. Most likely you're going to get approved because you've done everything we ask you. There is no like, hey, like I don't like this guy, so he shouldn't have a business.
But the property owner who's sitting there listening to this right now, who has a 2-acre parcel off County Road 77, that is not going to be in the commercial area.
It's not going to be, but like he has the chance to come and apply, and it's up to the quorum court to decide if this is viable or not.
So same process, different benchmarks to me.
Definitely, different benchmark and different like standards. Or you're going to say like higher standards, yes, sir.
Okay.
Yeah, we're not like telling everyone, anyone not to do whatever like the state or the law is telling you what to do or what not to do with your property.
Right. But it changes certain rights for certain property.
Or
I
like
mean,
the
by
mentality,
definition,
the mentality is sometimes like stuck on like I can do whatever I want. I mean,
well, no,
technically,
yeah, I mean, that left 50 years ago.
Technically,
we don't do that anymore. But now, if you are commercial, you have more freedom.
Yes, sir.
If you are not in the commercial, you have the same as what you had before.
Yes, and you have to justify it to a higher standards why.
Right.
Yep. We're not taking away any
no,
rights
yeah,
from anyone.
yeah. Okay, thank you.
No worries.
Justice Real Stafford?
Thank you. I'm up again. You know, once again, I want to thank the members of the public, you know, for surfacing, you know, different questions and things like that as this has gotten more publicity and, you know, sending those to us because I think just in general, the more eyes that are on something, the better people have found different things. One of the things that some people have raised concerns about is they're worried that we're opening up our state highways to seeing lots of billboards and signs and things like that.
So
And I noticed in the appendix, we actually do have a sign ordinance that the Quorum Court passed back in the 90s.
I added this specifically so people like will understand that like you cannot, if you cross the county, if you cross the county to the northern county, you can't see the billboards.
Yeah.
It looks like on the highway, you wouldn't have this here because of this ordinance.
So what it looks like to me, what this looks like, it bans what are called off-premises signs. Can you explain what off-premises means?
Off-premises signs, like normally, like we limit like the size of the sign, and you've seen this like in our like CUPs when people come here. It's like no bigger than 36 like feet, like so 6 by 6 signs. And if it's going to be lit, it has to be shining down. So it's the same idea as if you're like building any structure. It has to be shining down. So like there is no pollution, light pollution. We eliminate any like signs that's going to be ugly. An eyesore like to the public or to the street. We keep it like in the like within the business boundaries mostly. No signs is going to be on the right of way because like you cannot. So basically, we're trying to do whatever we can just to make sure like when you have a business, you're contained within your property and not encroaching or like affecting anyone else who doesn't want to see it.
Okay. So they can,
including the building setbacks and all of this. Like,
I
we'll
see.
try like to push back as much as we can.
so they might still have a sign, but on their own property and only within a
Yes,
certain
and it's
size.
never bigger than 6 by 6.
6 by 6, okay.
I mean, we'll
all right.
say like 36 by 6 or 36 like square feet, so it could
Yeah.
be 12 by 2. So.
Okay. Okay, and so let's maybe just take an example, right? So say somebody wants to open like a fireworks stand on a piece of property that is not zoned commercial, that's zoned agricultural currently. Walk us through the steps of that process. They first, they first notify the neighbors, they have to provide proof
Is it
of
something
that.
permanent, or it's going to be like one-time deal? So it's like the lemonade stand process. So you're going to have a lemonade stand, or like you're selling your flowers like you have from your garden. That's considered agricultural anyway. If you're going to do like a lemonade stand, or like swab meat, or like you're going to do like some sort of like
right.
selling anything like you need from your house, it's a one-time deal. It's not going to be continuous or permanent. We're not going to require you like to submit for any application, and that's still the same now. Lots of people like who come from outside the county or like the state, they call us and says like, hey, I need to fix my like fan within like my house. Do I need a permit? We'll say like, yeah, there is no building permit in the county, no inspection. It's a wise thing to call like an electrician so you don't have a fire, but like if you know how to fix it, we're not going to require you. Other places like cities, you have to have a certified person and you get a permit and you go through a process. And that's one-time deal. So it's not you're like going to have that lemonade stand or that yard sale or that flea market weekly, daily. If it becomes continuous, that's basically a business you have to apply for a permit for.
Okay, so say it's something continuous, right?
Yeah, it has
And-
to be continuous, and that's like
so-
now. We're doing
right.
this now.
So would they first go after they, notify the neighboring property owners and they provide proof of that to the county? Does that then go through 3 readings at planning first before coming to us? Walk me through the chart.
I mean, it's the process, like as I mentioned
Yeah.
it. So
Okay.
you go through like the quorum court, and the quorum court, like if they're going to approve something and have an ordinance for it, or like
So it'll come straight?
It comes to the quorum court
Okay.
first for like a business, and that's like the rezoning process.
Okay.
It comes to the quorum court, and the quorum court, I believe they have to do 3 readings. I believe like that's if they're going to like issue an ordinance, yes.
Okay.
And if it's approved, it goes back to the planning board. The question is it approved by the quorum court? That's the planning board question. Yes, it's been approved. We have an ordinance number on this like day, and then like we move forward like through the process. I'm not sure like our like staff were going to accept any process that hasn't been approved by the quorum court or like rezone
Right.
commercial to take it to the planning board. It will be like ridiculous.
Okay, so in other words, with the current CUP process, the CUPs first go to planning
Yes,
through
ma'am.
3 readings,
And then-
to the quorum court for 3 readings, and now
It's just
it'll-
basically reversed.
It'll come to quorum court first.
Yes, ma'am.
And then go to planning for 3
Yes.
readings.
And let's say like you the quorum court like meeting is like on the 22nd of this month. You need to apply for rezoning by the 1st of the month. Within like 14 days, you have to send before the 14 days meeting, you have to notify the neighbors. So you prove that like you already sent the notification out. If it goes through the process and it's been approved, it goes next to the planning board. If it's not approved, you have 2 options again. You either can reapply with a different prospect, or you can just go ahead and if you want to fight your process in the circuit court, you're more than welcome to do that. And from experience, we had maybe 1 project that went to the circuit court and it was overturned. And when this happens, the judge will approve the project and it becomes a law. So we cannot go and says oh, you cannot, you've been denied here. So that overturned this process if they can go to the circuit court.
I see, okay. And I guess when J.P. Taylor was talking about the grandfathering the current CUPs in as zoning, I guess that raised a question with me. Do the current CUPs, when there's a change of use, those expire, right? And if we move something to zoning, the zoning doesn't expire. Is that right?
I believe that's what Brian mentioned. That so if it's already been zoned and approved as a CUP, it went through the process. It's not going to be taken away from you.
Okay.
But I think if it's currently a CUP,
Yeah.
It runs with the land.
Yes.
Oh, it runs with the land.
And so
Okay.
this
I'm
wouldn't,
sorry.
this wouldn't
Yeah.
necessarily. I mean, if you sold it, they
Unless
could
if
still
the-
use it underneath that
Yeah,
CUP.
unless if the use has
Okay.
changed.
So what I'm saying is, I don't know that that drastically changes.
Yes.
And I just wanted to reiterate, zoning
Yeah.
is absolutely a legislative act. The quorum court must be involved in that, and the quorum court has the authority for that.
And one of the things we added to this code, like we said, like it runs with the land, just like to make sure people like understand it and
Right.
yeah, be aware, like and be assured. So
Sure. And you know, and I just wanted to reiterate, you know, for the public, on my 3 years here on the quorum court, we have seen problems with the CUP process, just like you talked about, where we have mom and pop business owners who basically spent what for most people would be their life savings.
yeah, 20, 30, 40.
Trying to get through this process, only to be denied at the very end. You know, and on the other side, we've seen folks who want to open a business and they buy a random piece of land, whatever they can find for sale, but it may be in a really inappropriate area, miles down a windy dirt road or something like
Yep.
that, and the neighbors have a problem with that. So
Yep.
I see some of the problems that we're trying to solve with this, you know, and I just wanted to kind of
Yeah,
reiterate that.
most of the JPs who live like outside city limit like will relate to that and like they know exactly what's going on because like some of them some people like they will just like start their own business and after the fact we'll call them and they said like you need to apply and they come and apply but most of the time it's hard for them to do exactly what we tell them to do because like they already started their own business but we try the best we can and we're trying to eliminate all of this. We're trying to give you the opportunity to do it right. Yep.
Justice Ricker?
Yes, sir. It looks like we're probably going to send this back to committee. What will be the process to change the map and/or the ordinance for modifications?
You guys can bring amendments to that like you would any other ordinance. if you
At
have
the
language or
committee,
something.
or are we going to do any changing before it comes back to the committee and comes back to us?
Look, what I would say is, if I'm understanding
Director
correctly,
Adder won't change anything.
he's going to
on
put
zoning.
his final draft out online with the map.
Okay.
And then I think when we get this back to committee, this is really where we want you guys' input to start carving on this and see if the language is right and the map is right. And I want to reiterate, you guys own the map. What we have done is just try to give you a starting point, which is staff's recommendation. But you guys can absolutely change that. And of course, that map will live. You know, understand that too, that will be an ongoing process. And so, you know, continue to take these comments, and yes, please, we would love to have suggestions and map suggestions.
I make sure like to remove and add anything like I feel like that it needs to after like we get suggestions. When we approve any CUP, like I added like all the CUP that we approved recently to this map. If there is anything need to be eliminated, like along the highways or like somewhere hidden that you think it doesn't have access to it, I'm like more than happy. Just like let me know, highlight what you think it is. We can discuss it, and it's an easy process.
I want everybody, you know, you can have the risk of be criticized of being heavy-handed. But my instructions to staff when they came up with the projected map, I said, come up with criteria of the parcels you would suggest and apply that uniformly across the county. So that we don't want anybody to think we're trying to designate certain areas and leave certain people out or vice versa. And so, yes, that map is basically everything we'd recommend using the criteria of the thoroughfares and the heavier highways. That's why all those parcels are there. And I hope you guys can understand and respect. We were trying to do that universally so that we weren't. But now this is the process to where the justices, you ladies and gentlemen, can come in and do that. I'd even go so far as to say if there's citizens out there and their parcels are proposed to be designated commercial, get with us and we'll take them off that map at the landowner's request. We're not here to demand anything. We're not here to impose anything. We're here to give people options. And so that's something we hear from the public, and that's something we continue to want your feedback back. You understand that that's just a big process for even directors add a team to go through. It's a big process to identify every parcel, and that's where we need help from you guys. We need you guys speaking with your constituencies, and we need the public's input on that also.
Yep, we're here to help. We're here like to do the right thing. We're not here like to annoy anyone. We're not here like to do anything that like nobody wants. So.
Just
yes, thank you.
Mr. Ada?
Yes, ma'am.
Could you go back just a moment when you were speaking a while ago when you said we flipped the process around? Let me know your thinking as why that is a better, because it seems to me like right now, before it comes to the Quorum Court, we have the advantage of hearing the people that come to the planning board meeting. We have the advantage of hearing the neighbors that come to the planning board meeting. And then it comes to the Quorum Court. So why is it better that, it seems like we're cutting out public input?
No, I mean, like, if you saw that, and you've heard me,
No,
like,
I
saying
haven't.
that,
I
like,
have
many
not seen it.
times, you have to notify the neighbor, like, a minimum of 14 days before the Quorum Court, so they can come and, like, object, or they can and support. So, it's the public, the public, they're gonna might be over, like, notified if it goes, like, through the planning board as well. So, everyone is gonna be notified. The public will be notified. That's just the state law. We're not taking this away. We cannot. Any public hearing, we have to notify the people about, so.
Okay, another question that someone asked me today that I didn't know the answer to. What will be the different duties between the Zoning Board of Adjustment and the Planning Board?
Okay, so it's within the definition. The planning board, like, they approve the project that comes through the planning projects, and approve the plans, and approve, like, the scope of a project. The zoning board of adjustment, they approve the variances to the code, and they can challenge some of the codes we have. That's the difference. It's the same people, but, like, different hats. So, and it's, like, in the definition. What's the and, like, I've heard, like, some question from the public says this newly established board. It's not newly established. It's been there, like, since they established the 2006 zoning. And it's two boards. The planning board, they have their function, and the zoning board of adjustment, they have, like, their function. Okay. It's completely separate.
And that's the current process. If you go to the planning board meeting right now, you'll see kind of the agenda split in two sections.
Yes.
That's currently the way they're operating. There's two boards, and they're the same individuals right now.
Yeah, it used to be combined, like, 3 years ago, like, we thought it's a great idea to eliminate them. So, like, the variances or anything that challenge the code itself, why we're doing this against the code, goes to the zoning board of adjustment. We adjourn, and, like, we start, like, establish another meeting with a new agenda, with a new minutes, with new everything. And we go, like, hey, now it's like land development, like, process, the conditional use permit, subdivisions, minor subdivisions, large scale. So it's two different processes, same people, different functions. We can always, like, move them around if you want to. It looks fun.
Okay. Another thing that one person contacted me about earlier was, under the definition on number 56, large-scale development, it didn't mention mining, and they were concerned about that. And I'm just asking if that's a concern, if that's something they should be concerned about.
If you look somewhere, I can't remember where exactly, improvement, we can always say, when you say, but, like, grading, that's basically mining. You're, like, changing the layout of the land. That's one of them. Anything, it's in the definition as well. Any land development that is equals to 1 acre or more becomes a large scale. And that's exactly what we do right now, hasn't changed. And we're trying to do this for that reason, for the grading. So the engineer will, like, impose a drainage or, like, drainage report, and they can impose a grading report just to make sure there is no runoff or, like, drainage issues. And on top of all of this, our contract engineer has the right within this code to go and say, even if it's less, like, than 1 acre, and we've seen this with the Kramer, like, conditional use permit that was approved, it was, like, about, like, 1.8 acres, but because of, like, the way it's being built and the grading, it was, like, so high, like, the coefficient was over, like, 2.5. The engineer, like, requested that, like, the applicant go and get, like, another, like, engineering opinion and do a grading and drainage report. Normally, people who do CUP, they don't have to do any of this, but it was necessary because, like, the lay of the land and the drainage that's going to create when you build that, like, concrete. So it's within the discretion of our engineer to go and say, yes, I see the need for this to go, like, through a bigger, like, scrutiny, and, like, we need to have this. Once our engineer says that, we have to follow based on this, and it's also based on the The idea is like we don't want to harm any neighbors.
Okay. Okay, I'll just, thank you very much. I appreciate
Absolutely,
it.
ma'am.
Justice Dennis?
Thank you. I think we placed this on the, when we placed this on the agenda, we brought it to everybody's attention. And so it went from way down low to way up high real quick. And I've heard from businessmen, lawyers, investors, farmers, realtors, just about everybody. And they're all excited about it. And, you know, so I came prepared to make sure that we tabled it until later on. So one of my questions is, are we parliamentary correct by sending it back to committee, or do we need to make a motion that we table it?
It would be parliamentary correct to refer it back to committee.
Okay, very good. I want to be sure we were correct. The other thing is, there's a lot of professionalism in this. I really enjoyed J.P. Taylor, you know, his legal respect on it. I find that when I don't know something, I try to get with those who do know. And I know the Northwest Arkansas Board of Realtors are very interested in this. They've contacted me and they would like to participate and like to help and like to offer their professional services to you know, their opinions about some of this. So I would encourage you to reach out to the community professional people and so that we can make fewer mistakes going forward. Because one word that has came up several times is grandfathered in. Recently, that was brought to my attention that it's not even it's not legal. You can't grandfather something in. Either it's right or it's wrong. You can't grandfather something wrong in. So I've heard you use grandfathered in quite a bit. Is that correct or is that incorrect?
Well, I can only speak for myself. What I'm probably doing there is using a layman's terminology. But I think the way we looked at that on the front end was there'd be no way we could go in and remove somebody's CUP in this new. I mean, I think that would be extremely unfair, and I think there'd be legalities on that side also. And so, yeah, if it's a grandfathered in, I'll take responsibility for that terminology, just to say that was what my layman's was, that we would give them the proper zoning for what we've already honored with the CUP.
Okay, very good. Thank you.
No problem.
Yeah, one of the biggest reason we have everything posted online so we can have feedback. I mean, that's why like we have the technology, we can use it. That's why.
Justice Hickey?
Thank you, Judge. Just to be clear, this does not include red dirt pits or mining in that large-scale development, correct?
It would in large scale. It doesn't include it in commercial.
Okay.
And so going back to, I guess if we're really trying to draw the line and make sure what we were doing. If a business or a mine already had a CUP.
Correct.
We were going to honor that in the new code.
Correct.
What is not happening at all is giving new designations through this map other than what we've proposed to you in commercial.
Yes.
And so there's nothing in here that we're trying to give within this first wave. This would have to come back to you guys of businesses that are coming in. We're trying to honor what we've done as a county, right, wrong, or indifferent, and also open this up for you guys to have say on the back end.
The second point, so thank you for that clarification. The second point is this map goes just the length of Washington County, correct?
Yes, ma'am. It doesn't go beyond.
It doesn't go beyond. I mean, it's just Washington
It's limited,
County.
yeah.
But it's not intended to, I would say, mar the beauty of this natural state. I know one of the ladies said just concerned about Devil's Den.
I
Now, that'd be hard to put
can't
it to
remember
six.
where it's at. Let me just find this if I can.
But I just want to
remember.
reassure her that that is not the intent of this court or this administration.
No, I mean,
Because we love living here also. We love the beauty of it.
While he looks that up, I'll speak to that. I think there's, when we were as a team, when we were coming into this process, what were our goals? We understand we're a growing county. We understand we're a changing county. You know, somebody told me one time, they said, you have the hardest county judge job in the state. And I thought that was an interesting comment. I said, what do you mean by that? And they said, you have a rural county trying to go urban. And I think we see that very much up to our north. There's just an influx. My intent was to shepherd commercial businesses into certain areas so that we can continue to try to preserve our agricultural heritage, our rural agricultural heritage in this county for as long as we can. And then I've also said many times, there's a selfish component to this, if you want to say that. This allows us as a county and other utilities that are operating within the county, I think of Washington Water, I think of other places, this lets us plan infrastructure. What we're doing right now is just shooting all over the map. So the lady who was up in public comments talking about the water usage, that is going to be an issue for our county. It's going to be an issue for our region as we move forward. But what I would say to her is right now, we don't know where to improve infrastructure when we're looking out into the rural parts of the county that are growing because we're just going haphazardly. And so, yes, that of course helps our road department make better decisions about where we're expending our resources. It helps the planning team make sure that we're putting people where they need to be. We're just trying to shepherd. Also, we are creating a marketplace. Mm-hmm. If you think about Washington County right now, if you are an interested business entrepreneur, you have to go out into the county, find a parcel of land that you can coerce somebody to sell or that is for sale with no planning of where that is. You just have to take the best available. And then we have to go through this very onerous process that Director Ada just described. And a lot of times your life savings are connected to that. Right now, what we're trying to say is the marketplace to me is, by designating this, is good for both sides. If I'm a landowner and I have land on 412 and I think it's time for me to move, I want to do something different with it, I'm given the opportunity to sell that land at the highest and best value, I think. If it's deemed commercial and it's more appropriate as commercial, surely I can attract a better price for that. But if not, you don't have to change it all. Also think about it from the entrepreneur's side. They can now go and see land that's for sale that is zoned commercial and know that they can come and adhere to the county's minimal standards and see that their project can be completed with the oversight of you guys as zoning and the planning board. So that's the advantage that I have really seen here.
Thank you so much for clarifying that, and I hope people heard that loud and clear, because that message was not out there, and I think that's why we got so many messages in various ways, and there was a heightened sense of anxiety, and that's one thing we don't want to cause. We want everybody to say, we're going to work together, we're going to collaborate, we're going to communicate, and I believe that's why it was intended to go back to committee, so that way we can communicate more and have better discussion and refine this. I thank you for clarifying, Judge.
I just want to say, if by accident or not, I guess now I can't regret that this has been called to the public's attention. I want those comments. I want to hear people's concerns. And so, yes, I'm glad we're here at this moment. Justice Coger?
Yes, one thing I forgot to ask you a minute ago was, and I'm looking at your little chart here right now, what criteria will we have? Like right now, we have a list in an ordinance that we use, like
this one here. We're talking about this.
Yes.
Okay.
Like we have one is compatibility, one is ingress and egress. Will those be the same under this new ordinance?
Yes, ma'am. I mean, like everything, as I said, everything we do, it has to go through the technical review. And based on like the opinion of the expert in the subject, that will notify all the departments within the county and outside, like the health department, our engineers. The biggest thing is like the engineering and the road department and the health department. We have lots of state like regulation we have to be to abide by. So all of this that's what we do right now. We might not see it, but we do have like technical reviews we do. If it's not in public because if the project is not that big, we do it like through communication. Everything we get feedback from, we add to the staff report. For instance, one of the projects I'm working on right now, it's a subdivision in Tontitown planning area. They were approved by Tontitown for various stuff. They were approved to do an extension to the main line from 2 to 6 or 8. It depends on how much they requested. They went through the health department request, all of this, the perk test, all the pets. And when it comes to the state, the state requirements, if you're building a subdivision, for instance, you have to have 2 two holes. Like one of them is like the primary and for septic, and the other one is like the secondary in case if the first one does not work. So all of this has been done through the technical review. When this all is approved, and with the grading report and the drainage report, goes back to the road department for like reviewing the streets and the roads and the minimum, and the engineers. The engineers look at the safety of the roads. They do like side triangles. Like anyone like who has like engineering degree knows what it means. So they make sure like look right. We have the AASHTO, like the state and like the country in general. They use this like regulations. All the engineers knows that height versus like side visibility if you're turning right or like you're turning left, and based on this, the street speed is like determined. So they do all the calculation for that, and they will tell you, okay, this part of the subdivision should not have, for instance, that radius. It needs to be bigger for safety. We have like minimum from radius safety and like entrance and the ingress egress for like the fire safety, a minimum of like 26 like feet like radius, and not more than 40 feet like for instance like driveways. It's all like for the trucks. If you have a subdivision, for instance, that has like a long street within it, and it exceeds 12,000 feet, you have a minimum of one turnaround. It could be a Y, a T, hammerhead, cul-de-sac, whatever it is, for like the fire safety. That's all like requirement by state, and that's not something like we're making sure it happens on the plan. So all of this is being addressed, and then the engineers will come and do their like review. It says like, I don't like this. This is based on the calculation is wrong. The coefficient here need to be changed. It goes back to the applicant and his engineer if it's a large scale or subdivision, and we give them about a week, and it's the same process we're doing right now. They come back with all of this, and so the resubmittal goes back to the engineer just to verify the information. Is this satisfactory to what like you requested? If they say no, it goes back again. If they say yes, we accept this and we move forward with the project. We have several projects that's been tabled for that reason. They never met the resubmittal day because they could not meet the requirements that our engineer or other departments, the health department or the safety. So they will be tabled, or like we'll say, hey, we'll see you next cycle. So go ahead, work on everything and resubmit again on date. All of this is being done now, and it's going to be transferred with the new one. We're not going to be eliminating anything that is like good for the public, so it does not make sense.
So if we would be okay then if we denied someone based on incompatibility?
Yes, ma'am.
Okay, thank you.
Justice Taylor?
Thanks, Judge. One thing I wanted to kind of bring to light or remind folks of that dawned on me as we're sitting here listening and trying to absorb all this is that, you know, by definition, and I've been involved in hundreds of millions of dollars of real estate transactions since 2008 when I started my career. There is no such thing as the government granting more rights in your property, right? By definition, you start with a bundle of rights, and you own real estate, and a law gets passed that, we'll call it, adjusts those rights. It doesn't grant more freedom. It manipulates and constrains and changes not your ownership, because that's literal, but your usage. And so these usages and these subtle ways that we need to be careful and cognizant of the erosion of how we view other people's stuff, meaning other property that doesn't belong to you or me. I'm talking about everybody sitting here, needs to be at the forefront of our brain as we just kind of get lulled to sleep under the presumption that we're going to do something. Like, I don't know. I've not heard a sales pitch, pro or con, that something is a fire and needs to be put out by passing, this big sweeping ordinance. I'm not saying it's not. I just haven't heard it yet. And so, the concept that this is coming, oh, you might as well get ready for it, that's not true. So, beyond that, it's what needs to be changed, if anything, and how does it affect somebody's ownership of real estate in this county outside of a city limit. And so, that is how I'm trying to, approach these conversations and approach this ordinance is that what is this erosion on one hand and maybe some expansion on another, but again, there's no granting of anything, rights are rights. And what does it do from a county perspective and from a private ownership perspective, and how do you balance the two things, if at all? So, I appreciate your input, Sam. It's invaluable. And, the thing that scares me the most about this ordinance, is the engineering. Like, how do we know if any of that stuff is,
Well, the engineers have codes and they don't want to lose their licenses.
No, yeah, that's true. That's true. But I'm saying in the actual ordinance, how do we vet that? If you were sitting here, how would you vet that part of the proposed ordinance?
It's back and forth between the engineers. Whenever we have a project that engineers are involved, and I mean, each project we have goes to the planning board or the zoning board of adjustment, has to be viewed by our engineer.
No, I'm saying the codification of engineering specs in this document. How would we know how to change something if it needed to be changed? I guess is what I'm asking.
From like the drawings or anything like
Yeah,
that?
yeah.
Okay, so the drawing were done by an engineering firm here, in Fayetteville, Johnson. But it's in Fayetteville that they work with the county. They've been working with the county for 20 plus years. So they know our they read the previous code. They know exactly what the road department is asking for. They know how the standards work in the state and what they've been doing within the county or the cities. So those drawings is not just we made up something. That it's actually...
I'm not accusing you. I just have no way to know the difference, literally.
Yeah, so all those drawings that we used to have, and I can send you the old one, it looks archaic, you cannot even read them.
Yeah.
That's been updated with the up-to-date requirements. Once again, the
technical stuff is difficult.
Yeah,
is what I'm
it's
getting
the
at.
fire code. It changes each few years,
Right.
and we have to adjust to it. So maybe 20 years ago, when someone had a door that opens indoors, now it has to open outdoors, or has to be outwards. So if you go to Lincoln to some of the old restaurants, most of them they're still haven't been retrofitted because they cannot force them. But it's a good idea to have this. So those drawings, those regulations, the engineers are up to date with it, and that's why one of the things we needed to do
Was update the
just
engineering,
updating
the
that.
technical part
Yeah.
of it. Okay, that's great. I appreciate it. Thank you.
Yep. Yeah, I know. Primal fear is legit. It's it's always there. Yeah, we're not taking anyone's property, and I've had this question before when we send neighbor notification, and we have the area that shows the area that's been notified. Someone would call me and says I live there. Is this going to be taken? And I said, no, dude. We're just sending you a letter, so it's coming.
Justice Bond?
Yes, sir. To start with, you might call this a disclaimer, but I express much appreciation to Ozarks Electric and Ozark Go. But I've had several calls. People are concerned. And I might start out with Highway 16 East. And yes, several people have lived out there all their lives, and some of them are elderly, and they want to see it remain agri and single-family dwellings. And they call me because they want me to represent them. And this is people I've known quite a while. I've had dinner with them on occasion at Durham. But one of the things that probably causes them to be overly concerned is, okay, we're talking about encouraging more development on Highway 16 East. Okay, we're encouraging that. We're saying, well, it's good for the economy, and we need to give people this freedom and everything. But in the Durham area, because of the growth, and the power company has to keep the voltage up to supply power to these areas in the outlying parts of Ozarks Electric there's a booster station.
Yep.
That has to be, and Mr. Sam's heard about it many times. I'm sure, it's necessary. During peak times, these generators have to be fired off, and the people that live in those neighborhoods describe it as
Noisy.
all of a sudden it's kind of not like a rural area, because you have engines that with turbocharged engines fired up. It sounds like a jet at the end of the runway with the brakes on and revving up, getting ready to take off, but it doesn't quit. It never takes off. That's what they have to live with until hopefully 10 o'clock at night. Maybe it'll shut off. But we're talking about encouraging more growth in that area, and that's one of the things. And I think the power company's doing everything that they can, what they have to do to make sure we don't have a brownout. And that's one of them, 16 east of Elkins, and on out to the county line. The people, they want that rural atmosphere. I even had I could talk about, jokes are made about these little retail stores that pop up, and you only go a mile or two. They just soon drive to Elkins to get their, dollar stuff.
Yeah, once again, the electric is one of our biggest, Ozarks is one of our biggest reviewer, and we always follow the regulations and their standards or whatever they ask us to do. For instance, here is a project that's been approved last cycle. So, and that's the synopsis of the project. It's about 1 page telling you exactly what's happening, what needs to, and that's the stuff we sent you guys, being maybe a week before the planning board. Here's the light commercial definition that's exactly embedded right now. So utility condition, that's the standards. Ozarks, they have their own conditions. So we add all of this. SWIPCO, they have their own condition. This land was very unique that it has 2 companies providing electricity to it. So we know that the applicant is using Ozarks. We added SWIPCO just in case he decided to split and sell the land, so the next guy in line, he knows exactly. Water conditions, Springdale water conditions, it's the biggest. It's a 17 requirements. So we're trying to do the best we can with everything. We ask almost every entity we can ask to give us a feedback.
I'm not, in any way gonna pretend that
No, I understand.
I could do without Ozarks Electric or Ozark Go.
Yep. And for instance, that project has 13 conditions on it from the planning only, just to make it compatible.
They do everything they can.
Yep.
And still where we can have a quality of life.
Definitely.
So anyway, I'm just making some statements because I had several calls, and another one is.
And on a personal level, I need to thank you because you've been there from the beginning.
Okay, if you go out 45 east of Fayetteville.
45 east.
You've got a portion of that corridor is in the Mud Creek watershed.
Mm-hmm.
The Mud Creek runs into the Illinois River.
Yes, sir.
Not that our little part of it is, great big in the grand scheme of things, but we don't necessarily need to keep veering away from that single-family dwelling on a minimum size 1 acre lot. Because you get downstream from there, let's say out to Savoy.
Savoy to the west, 16, yeah.
Okay. We're contributing to flood issues out there. If you've already got saturated ground and then you say you get a 3-inch rain. And the way that you're generally gonna detect that by, not necessarily having to drive out to Savoy, there are times when the Illinois River Bridge between Farmington and Prairie Grove is impassable. And I don't believe the highway department designed that to where they figured that would ever happen. I'm just saying, I'm not saying don't build anything else in that Mud Creek watershed, but we don't need to encourage more than a single family dwelling on a 1 acre lot. It'd be best if you could keep it agri, but I don't see that happening. Then if you get out on 45 East east of Goshen, that's pretty much rural scenic. You get a lot of traffic out that way, people going to War Eagle. That's only seasonal, but they want to see that stay rural, and so do the people that live out there.
And need to reiterate what like Judge says, we're not forcing anyone to change anything.
Well, sure, but 71 South, that's a designated scenic highway.
Mm-hmm.
Do we really want to encourage more commercial business to go in there? I don't mean to sound selfish, and I don't drive it enough, but I truly enjoy being able to take Highway 71 South, maybe bop on down to A to Z or whatever.
I want to jump in here and say, if that's the way the Quorum Court wants to go, they can certainly adjust this map.
Well, okay.
We wanted to add rights to people's lands. You're talking about taking them away. And that's what makes us uncomfortable as a planning staff. That's something that you would have to do as a Quorum Court member.
To kind of put that straight, those rights were taken away
in
years
2005.
ago, and I actually fought it tooth and nail.
And that's what we're saying, that would be up to you guys to have those suggestions and put into the map, for sure.
But now that people have had those to live with and have seen the value of some of those the conditions, those are just things to think about.
Absolutely. And that's what we're saying back when I said the criteria when I gave the planning staff to try to make sure that we were being independent.
We're growing.
Absolutely. I told them to pick the criteria and select the parcels for that first map. And so these are the kind of considerations that we do want to hear from you guys, and that we think you guys should make amendments to the map and vote on as we work through it.
We're growing big time. Do we want to add racing fuel to the engine?
And I guess that's your opinion.
Okay.
My thing is the racing engine's already here.
Thank you.
Mm-hmm. Justice Lemming?
We've talked a lot tonight. We've talked a lot about a lot of things. I've been here 60 years in Washington County, and 71 right behind us here was the main highway. Bypass wasn't there. It's fixing to be 6 lanes. 412 is suggested so bad you can't even get across town anymore. We're growing leaps and leaps and bounds. We have no choice. And all of you citizens, I've got land out in Evansville, Arkansas. I don't want none of these turds to tell me what to do. But that's not where we are. Where we are, we're growing so fast. And like it or not, it's coming. And I want to be part of it to help y'all, me. I want us all to be happy to get where we got to go. And It's going to be hard, but we've got to work together to get where we're going. And I don't want to take anybody's property rights, and I don't want y'all to come bother me. I got 110 acres, my house is in the middle, and everybody around me can kiss my tootie. That's my attitude about it, and I want everybody to have that attitude. But we all got to realize, they say in about another 30 years, we're going to have 1 million people in Washington County. And Beaver Lake ain't going to give everybody drinking water. You may think it is, but it's going to go dry with 1 million people here. But let's help this Quorum Court, the new Quorum Court. Let's help farmers. Let's help all you people. Let's put this thing together to where we all like it. I don't like a lot of what's in here. I don't want the JPs to be took out of this. I don't want the judge to have all the power. I don't want the planning commission to have all the power. I want all of us to have all the power. I want this guy right here to have people to enforce what's going on in Washington County, because we have got so many businesses in Washington County right now today that does not have a CUP. And he has no power to enforce them. That judge has a little power to enforce them, but if he gets out in the rural part of Washington County, he'll get his butt shot, because that's the way people operate down there. So we got to help this whole process get where we want to go. And I hate it, but we got to do something. Maybe we don't need to change it all at once. Maybe we need to get the zoning stuff cleaned up, get a lot of paperwork cleaned up, and take baby steps and get where we want to go. But we've got to make this job easier somehow, some way. And it's just a lot going on that we've got to work together somehow to make this all happen. Thank you.
Justice Lyons?
Thank you, Judge. A lot of good discussion. Obvious, we need to do some more work. I believe the most work needs to be done on the map. I mean, the judge's direction to the staff to what they did to get started is a good one. I think we need to take more time. I don't know, we've looked at that map. I know we haven't discussed it very much at all. And I feel that that's a big part of what we've missed right now. We got to go back and look at it. I mean, I agree the highways is where the infrastructure is. It helps us understand it's where our infrastructure needs to be. It's where commercial needs to be. But does it need to be all the way up and down from the east end to the west end? Not really, right? So I think we all need to look at that. You know, people talked about 303 and what's out there. Does really need commercial out there? You know, we're the people really combining and living, and that's probably where we need the most commercial. But again, we need some work. We need to look at that, and unfortunately, sorry, Sam, haven't been able to look at it in 2 weeks. So anyway, I'm going to loop this all the way back around to the beginning. I move we send this back to committee.
I have a motion to refer back to the County Services Committee by Justice Lyons. I saw second by Justice Bowerman. Excuse me, sir. Bowerman. All those in favor? Aye. Those opposed? That the ordinance 9.1 will be moved to the, making sure I had it right, 9.1 will move to the County Services Committee. Ladies and gentlemen, that brings us to our committee reports. Those reports are in your packet. We had a combined Finance and County Services Committee for the